What is an heirship affidavit? When someone passes away without a will, it can create uncertainty for the surviving family, especially when it comes to managing property or other assets. In Houston, Texas, one legal tool that can help in these situations is the heirship affidavit. It simplifies estate administration by formally identifying who is entitled to inherit when no will was left behind. This document can be essential in avoiding court-heavy probate proceedings. In cases where the probate window has closed or the estate primarily involves real estate, it's a practical solution to transfer ownership to rightful heirs with less complexity. In Texas, the heirship affidavit plays a direct role in intestate succession, which is how estates are handled when no will is present. Texas law outlines how assets are distributed, prioritizing close family members. A surviving spouse and children from the marriage typically receive the community property, while separate property follows a different set of rules depending on which relatives survive the decedent. If no immediate family exists, the estate may be passed on to extended family or even more distant relatives. All of this is governed by the Texas Estates Code. So, what is an heirship affidavit? It's a legal document used to confirm who the rightful heirs are when someone dies intestate, that is, without a will. It lists family members, their relationships to the decedent, and how assets should be distributed. This document is especially useful for transferring real estate, allowing families to avoid the cost and time of probate court. Heirship affidavits become particularly important when more than 4 years have passed since the decedent's death, making formal probate no longer an option. If you're wondering who can file an heirship affidavit, the answer is very specific. The document must be completed by 2 disinterested parties, not heirs, who are familiar with the deceased's family history. These individuals must be impartial and legally competent, and their statements must be notarized. This structure helps ensure the validity of the information provided and minimizes the risk of conflict or fraud. How do you prepare and file an heirship affidavit in Texas? First, gather essential details about the decedent and their family. Then, identify 2 disinterested witnesses who knew the deceased and can vouch for their family relationships. The affidavit must be filled out with accuracy, signed in the presence of a notary, and filed with the county clerk's office where the property is located. Filing fees usually range from $50 to $75. Once recorded, the document becomes part of the public record and helps establish a legal chain of title. This process is often used when probate isn't feasible, either because it's been too long or the estate is limited to real estate. It's also an effective method when heirs are in agreement and simply need a valid legal path to transfer property ownership. The heirship affidavit is a helpful resource, but it must be done right. Consulting a probate attorney ensures that the affidavit is completed correctly and that you're following Texas law every step of the way. A lawyer can help prevent errors and avoid disputes that could delay or derail the process. If you're working with a law firm, you'll have guidance on legal procedures, requirements, and filing specifics, things that can get complicated without professional help. If you're dealing with a loved one's estate in Houston and need help understanding or filing an heirship affidavit, the team at the law office of Whitney Thompson is here to assist. Our attorneys provide practical legal support tailored to the unique details of your case. For help navigating this process with clarity and confidence, call us at 281-214-0173 or visit us at 4201 FM 1960 Road West, Suite 360, Houston, Texas, 77068, United States.